It is a real pleasure to deliver this keynote, and I want to begin by acknowledging you, the participants. Moot court competitions of this kind are not peripheral to the development of international environmental law. They are part of it. The arguments you construct, the principles you interrogate, and the positions you defend will sharpen the thinking of the next generation of lawyers working on exactly these issues. Moot court competitions occupy a unique space in legal education. They ask you to do something that textbooks cannot fully prepare you for, to construct a coherent legal argument under pressure, defend it against scrutiny, and engage seriously with the other side. In the field of international environmental law, where so much is still being interpreted, contested, and developed, that skill is essential. The lawyers who will shape climate jurisprudence over the next 2 decades are in virtual rooms like this one today. The rigor you bring to this problem, the quality of your reasoning, and the creativity of your arguments genuinely matters. The world you're being trained to serve is facing a profound crisis. The climate is becoming increasingly unstable. Global warming is projected to reach approximately 2.8 degrees Celsius above the pre-industrial level by the end of this century. And even if every country fully implements its nationally determined contributions, temperatures are still expected to rise between 2.3 and 2.5 degrees. So quite clearly, we are off track. We already know that climate change has a tremendous impact on human rights, humanitarian needs, welfare, and dignity, particularly for those in vulnerable and marginalized situations. In many ways, it is rocking the foundations of peace and security. Consider Africa for a moment. The continent emits less than 5% of global greenhouse gases, yet it carries a disproportionately heavy burden because of its high vulnerability and limited adaptive capacity. Climate variability is already negatively impacting the health of tens of millions of Africans, exposing them to extreme weather and the spread of infectious diseases. And looking ahead, by 2030, around 118 million of the continent's poorest people could be further exposed to droughts, floods, and extreme heat. That is, if we do not design and put adequate responses in place. Anchoring solutions in law is critical. We need to advance the environmental rule of law. And this is where law comes in. Strengthening environmental governance is one of the most effective tools we have to tackle this crisis. But it's not just about having policies on paper. It demands effective institutions, credible enforcement, and real accountability mechanisms. And this is where the environmental rule of law becomes significant. It is the foundation for translating environmental rights and obligations into actual action. Without it, even the most ambitious laws and policies risk remaining symbiotic rather than driving the systemic change we need. UNEP's Environmental Rule of Law report makes this gap very clear. Over 176 countries have environmental framework legislations in place, but implementation and enforcement continue to be the weakest link. So it is not just the absence of laws that is the problem. It is how effectively they are being applied and enforced. Robust legal and policy frameworks provide predictability. They safeguard rights. They create fair conditions for decision-making, enable participatory governance, and ensure that environmental protection is not sidelined by political expediency or short-term economic pressures. UNEP supports this work through its Montevideo Environmental Law Program, providing technical legal assistance, capacity building for legal professionals, and research on emerging areas of environmental law. It is work that connects directly to what you're doing in this competition. Courts are indeed agents of climate justice and accountability. And I'd now like to turn to courts. Across the world, citizens, communities, and increasingly corporations are turning to courts. Courts are becoming a critical avenue for securing accountability, safeguarding rights, and compelling action, especially when other routes fall short. UNEP has been tracking this trend in climate litigation since 2017, and the numbers tell a clear story. Between 2017 and 2025, the number of climate litigation cases has gone from 884 to 3,000, with a notable rise in cases originating from the Global South. Cases from the Global North are also shaping the conversations in important ways. The Klima Signorinen case before the European Court of Human Rights, where state inaction was recognized as a violation of rights, Germany's Nuremberg decision, which mandated emissions reductions to safeguard future generations, and more recently, the Lua case, which pushed the question of corporate liability for greenhouse gas emissions. Together, these cases are re-envisioning how we think about climate justice. This is also reflected in UNEP's recent work on the right to a healthy environment. In its analysis of trends across a decade from 2015 to 2025, UNEP found that courts are increasingly reaffirming the centrality of the climate system to the recognition and sustenance of this right. Now, only around 2.1% of climate litigation cases recorded have been filed in African courts. But this does not mean that issues of justice are not at play. Civil society organizations continue to challenge the construction of the East African crude oil pipeline on the grounds that it was built without proper environmental, social, human rights, or climate impact assessments. And climate cases are increasingly no longer confined within national boundaries. They are constructing transnational narratives, which is exactly where this moot court competition becomes significant. This includes the landmark advisory opinions from the International Court of Justice, the International Tribunal for the Law of the Sea, and the Inter-American Court of Human Rights. And we are still awaiting the opinion of the African Court on Human and People's Rights. The ICJ advisory opinion, delivered in July 2025, is particularly significant. It clarified that states have legal obligations to both mitigate and adapt to climate change, grounded not only in climate treaties, but also in customary international law and human rights law. And importantly, it extends responsibility to the actions of private actors within a state's jurisdiction. When you take this together with the opinions from ITLOS and the Inter-American Court, we now have a much clearer and more authoritative interpretation of the legal framework available to address climate change. These developments are expanding the legal foundations for climate action, deepening accountability, and strengthening the role of international law in responding to these crises. Which brings me to why the problem you have been given matters. Though fictional, the moot problem raises very real issues. Around 92 million tons of textile waste is generated globally. This is equivalent to a truckload of clothing being dumped or burned every single second. And a large proportion of this waste does not stay where it is produced. It is exported to countries whose waste management systems are ill-equipped to handle it. What you see in this moot problem is not hypothetical. It captures exactly where international environmental law is today. You're being asked to deliberate on an increasingly urgent question. What are the legal obligations of states when harm is caused through global value chains, in this case, textile and apparel waste? And that takes us directly back to the ICJ advisory opinion, because what the ICJ clarified is that states cannot look away from harm. even when it is driven by private actors. That is exactly what this Moot problem is testing. So when you engage with circular economy approaches, reuse, recycling, extended producer responsibility, remember that these are not just policy preferences, they are legal necessities. And crucially, what you are engaging with in this Moot is not a settled area of law. It is an evolving space, which not only makes the challenge more interesting, it means the next generation of lawyers, your generation, has a genuine contribution to make to a larger dialogue on solutions. The arguments you develop here, be they on due diligence, on transboundary harm, on circular economy obligations, are exactly the kinds of arguments beginning to appear in real courts and real disputes. So treat this problem as more than a moot competition. See it as an opportunity to engage seriously with one of the most pressing legal challenges of our time. Be creative in how you think about responsibility and how you interpret existing principles. Stay grounded in both law and justice and think about how they can be reimagined to drive the systemic change our planet needs. I wish you all the very best.